donors in their assessment of what the person's best interest is. And last but not least, the consequences, if any, of a wrong decision being made. Now, this session will be moderated by Sim Bok Ing, partner of Wong Partnership LLP, and the panelists for this session are Her Honor Judge Carolyn Hilda, Senior Judge, the Court of Protection in England, Her Honor Judge To Wee San, District Judge, Family Justice Court, Singapore, Alex Rapkin, Barrister of 39 Essex Chambers, England, and Christine Smith of Christine Smith Estate Lawyers, Australia. A gentle reminder to all participants, questions, Q&As regarding this session can be submitted through the MicePad platform Q&A function. Now, Bok Ing, are you ready?
Yes,
let's go. Let's go.
Okay, good afternoon, everyone. Thanks for joining us this afternoon. And we really have a good and interesting panel to discuss very challenging issues. So let's start with the first issue. What is the role of the person's past and present wishes and feelings in the determination as to what is his or her best interest, and how are these assessed by the courts? We are all aware of Section 6(7) of the Mental Capacity Act, which provides that in the determination as to the person's best interest, a donee or deputy must consider, so far as is reasonably ascertainable, the person's past and present wishes and feelings, and in particular, any relevant written statement made by him when he had capacity. So what are these past and present wishes and feelings, and which of these are relevant to the best interest of the person? So, Honourable Judge To Wee San and Her Honour Judge Carolyn Hilda will share their views on this issue. So, Judge To, would you like to start first? You're muted, Judge To.
Hello, testing. Is this okay?
Yes.
Okay. Thank you very much for inviting me on behalf of my organization to speak for this conference. So I'm happy to be here and to share with everyone what the courts have seen, some cases that we have come across when ascertaining the patient's wishes, and what is the legal position in Singapore. Next slide, please. Okay. First, I set out what is the legal position in Singapore today. We have the Mental Capacity Act, the MCA, which is the legislation governing what happens when a person loses his capacity. You know, what are the factors and things that we need to consider, and when the deputy comes to court to seek a court order, how does the court rule in each case? So, first and foremost, Section 3 of our MCA sets out 5 principles on what does one have to consider when we look into all these issues. So do have a look at this when you have the time. And in particular, the Section 3, Subsection 5 says that any act or decision made must be in the best interest of P. P here refers to the patient. And the next question we will ask is, what then does best interest mean? What amounts to best interest? What are the factors that we must consider when we talk about best interest? And all these are listed in Section 6. And looking at what Bok Ing has shared just now, Section 6, Subsection 7 is what I want to talk about in more details, which is past and present wishes. Subsection 7 of Section 6 MCA says that one must consider the person's past and present wishes, his feelings, in particular, any relevant written statement. For example, did he keep a diary? Did he record down? Did he write any letters? Did he make a will? All these are written documents that he made when he had the capacity. What kind of beliefs and values that he will likely influence his position? Maybe some of them, elderly folks think that I would like to stay with my eldest son, my oldest child, for example. Other factors that the patient would likely consider if he was able to do so. If you look at all this, you will think that, hey, these are really very important considerations. Yes, I agree. However, we have seen that they are not easy to implement in practice. Next slide. Okay. The The common facts that I have seen when I hear cases would be, in majority of the cases, when the patient comes or when the application is made to the judge, the patient, who is P, is no longer able to communicate any of his or her wishes and feelings. These are the very clear-cut cases whereby you just can't get anything out of P anymore. And when you try and find out, is it true that really P wanted to sell her house, P wanted to spend her money this way? There is a complete lack of written evidence or contemporaneous evidence for P. Okay, so what you have would really be the deputy or the family members' words, and many of these persons who make the applications will have that vested interest. They are the ones who actually intend or would like to have this happen, to sell the house, to realize the money, etc. So their evidence becomes unreliable and maybe subjective to a certain extent. And then we have another category whereby the patient, P, is still able to communicate. These are the high-functioning patients. Usually these kind of patients would be perhaps born mentally retarded. So they are able to actually live on their own and kind of run their daily lives. However, when it comes to making decisions of certain complexity, he or she are not able to do so. And there is a medical report supporting that this person has lost mental capacity. So he can communicate, but he appears to be highly influenced because the deputy or the person taking care of him is somebody that he depends on very much. So he tends to want to please the person. He will suppress his real wishes, his feelings. And next is P's wish may be detrimental. We have elderly folks who would like to stay with the male child. However, the male child is somebody who is not suited to take care of P. Okay? Or his wish becomes unworkable given that he is in such a condition that home care is not suitable. He may have to go to a home, etc. But P's wish may be that he doesn't want to go to a home. But you have a deputy coming to ask for orders to put P in a nursing home. So, you have all these tensions pulling in different directions. So what will be the best interest of P? How does the court execute what is the best interest of P? Next slide. So how does the court deal with all these situations and what does the judge do? And of course, you as a lawyer, you'll be interested to find out how do you convince or persuade the court to give you the orders that you are asking for. Okay, so it is not an easy job. I myself find that I spend sometimes a lot of time thinking about it, scrutinizing the evidence, and just really thinking deeply what is the best interest of P and what should I do? What would be the best decision to make for P? Okay, so these are some of the methods or manner in which we approach each and every case, which is different. Okay, first we review the contemporaneous evidence, which in my view is a strong indicator of what would his wishes be. Okay, he might have kept written trails of what he or she wanted. However, we also have to bear in mind how long back this, if this was done like 30 years ago, is it still valid again? Is it still valid today? Okay, we look at some of the letters that he or she might have written. And I had one case whereby P made a will that she wanted to distribute her monies, her assets in a certain manner. However, the way in which the deputy has asked the court to allow the disposal of some of her assets go against what she wanted in her will. So I pointed this out to the deputy's counsel, and after thinking through, they were willing to withdraw their application. So in that sense, they respected P's wishes. Next, interviews with P. Okay, this probably would only be possible if P is still pretty high functioning, which may not be very often. We do see cases of high functioning Ps, and what comes to mind would be two cases that I had come across. One was, both of them were mentally retarded persons. And first one was, a female in her middle-aged female, but of course, being mentally born in that condition, mentally retarded, she was, still very naive, and her intellectual ability was probably like below 10. So I interviewed her in order to ascertain what she wanted, and I was comfortable and was persuaded that indeed that was what she wanted. Okay, the second case that came to my mind was not so straightforward. In the second case, P was an elderly male. Okay. He was probably close to 60, lived all his life with his mom and sister. So in the family home, HDB flat somewhere in Singapore. But very unfortunately, the mom passed on, with age. And then the sister also had a stroke, so was not able to stay with him anymore. So for a while, he was just staying alone. Right? He's mentally challenged, but he stayed alone, and he was able to lead his life. Of course, he wasn't working by then, so he was going to something like a daycare every day. He could go to the daycare, or he had transport, something like that, and he had meals delivered to him after he comes back from daycare. So he could do simple housework. He could wash his own clothes. He couldn't cook. He wasn't allowed to use the cooker and all that. So he had food delivered to him. And the person caring for him was his older brother, who was probably about 70-ish. So in my view, quite elderly. And the older brother suffered from cancer for a while. So when the application was made to me, the older brother's cancer was in remission. But of course, the older brother was very worried that he may not be able to do it for long. Okay, so he put in the application for deputyship, and one of the key things actually that he wanted was he wanted to uproot P. He wanted P to sell the flat. He wanted P to move from the place that he has been staying maybe for the past 40-50 years. And he wanted to move P all the way to another part of Singapore, so that it's like one bus stop away from him. So here we have P, who obviously is mentally challenged, not as able to adapt to changes as a normal person, and he's quite comfortable, happy with his life, his daycare, his friends there. When I interviewed him, he was able to tell me, the buses he take, what were his favorite food, which hawker center he goes to. So I could tell that he was happy, he was comfortable. But when it came to asking him, are you sure you want to sell this? Straight away he was like, it's okay, it's alright, never mind, I will sell, I will change. And when you ask him what happens if what if you don't like it, what if you become unhappy? So he had no answer. So the only thing he kept saying was, it's okay. So I felt that there was a big element of perhaps reluctance to share with me more, or maybe even fear of going against the older brother's wishes. And I also talked to the brother, who was quite frank, that he told me that, look, it's really not easy caring for P. When he's ill, he doesn't even know how to take his own medication, and I have to rush over at very late hours, etc. And here I am, I have my own life to take care of as well. So I was not confident, I was not comfortable whether it was really in P's best interest to uproot him as what was applied for by the deputy. So after talking to P, after talking to the applicant, I was still not comfortable. So what happened was I relied on Section 35 of the MCA. Okay, Section 35 says that the relevant ministry can appoint a board of visitors, which we do have. And the board of visitors consists of two kinds of visitors. One is the special visitors. The second type is the general visitors. Basically, the special visitors are doctors, registered medical practitioners, and the GVs, the general visitors, are social workers, psychologists, people who have experience in this field. So I sent in two visitors. One was SB and one was a GV. So they conducted surprise visits to P. Okay, so they went to see him unannounced, and they were satisfied that, hey, he really could take care of himself. He could cook. sorry, he couldn't cook. Yeah, he was not allowed to go near the stove. He could actually do simple housework. He could do simple laundry, and I think, and P being P, because he is quite simple and all that. So when he was in the natural setting, he actually shared a very different view from what he told me when he specifically came before the interview with me. So at the sessions with the visitors, he expressed that he's happy. He don't want to move. He was happy to be there, and he wanted to carry on with his life there. And I also asked for a medical opinion from P's doctor on whether whether there will be any adverse effects on him if we were to uproot him and force him to, go over what if it doesn't adapt, what's going to happen, etc. So of course the doctor acknowledged that with being in this condition, being mentally retarded, it will be more difficult for him to adapt and etc. So well, the medical opinion was again borderline, half. It doesn't swing either way. So, but this story had a happy ending because the social worker came up with a solution that I think perhaps not to move him, but also the long-term plan would be to ship him into a home eventually. Because the brother's worry was that I'm getting old, I don't know how long more I can do this, and P is also getting old, so we also do not know how long he can carry on to stay on his own. So the plan then was for him to transit to a home eventually. So the outcome of that was the application was not successful. I didn't agree that it was in P's best interest to uproot him and shift him over. Right? I felt that it would be okay for him to stay on, and then we have a plan on how to move him from the daycare to a more permanent home for mentally challenged elderly persons. So this is one other case that I felt that we had to really pull out what is his genuine wish, because he is so torn that he didn't want to go against the brother. Obviously he also loved the brother a lot. I mean, who is his dependent. But we had to go through quite a bit. It took us at least, I think, a few months to carry out all these visits, to slowly talk to him, and a formal report was put up to me, and I also had interviews with him. So in the end the application was not successful. I was not persuaded, so he carried on, and I explained this to the applicant, and he was able to accept it. So I think it shows that he did put his best interest first as well, because to him was okay, as long as there is a solution, which is that we are going to transit him to a home. In case I'm not here anymore, somebody can take care of him, right? So I think in conclusion, is my time up? More or
Yes,
less,
you're right on the spot.
Okay. Last words for my session. Okay, I think as for the solicitors or for the lawyers in this room, what I would request or say is when you are dealing with such cases, it's important for you to carry out the due diligence. It's important for you to know P a bit more, to talk to him, if you can. I know majority of the case actually P is more or less not able to communicate anymore, right? So it's quite important if you can to talk to P to find out whether there's any such telltale signs of his genuine wishes, of any contemporaneous evidence that can show us more what were his wishes when he was still able to express them. And all this would be very helpful to the judge who will be tearing her hair out. Because it weighs so heavily on me that I have to uproot him from his home of 40 years, to a completely new place. I was genuinely very worried whether he would be alright or not.
Yeah. Not
Okay,
easy.
thank you very
not
much.
easy. Yeah, thanks so much, Judge Do. Judge Hilda, do you face similar challenges in UK? You have a bigger population and your court of protection has been around much longer. I'm sure you have more interesting stories to tell as well.
Take myself off mute. Firstly, good afternoon, good morning from England. Thank you very much for inviting me to address you, and thank you to Judge Toe for everything that she has just said. Our statutory framework is so closely aligned that saves me from dwelling on the substance. Thank you very much indeed. I will instead try to offer a few insights as to how it works in practice in the English jurisdiction. So our equivalent to your section 6.7 is 4.6, just to be confusing. But just the same, the court must consider past and present wishes and feelings, and in particular any relevant written statement made by the protected person when they had capacity. In most welfare matters, it seems to me that the focus is usually on present wishes and feelings, and perhaps this is a difference in our jurisdictions, because I wouldn't say that most cases involve protected persons who are beyond being able to express wishes. On the contrary, I would say that most Ps, most protected persons in the English jurisdiction, actually are able to express wishes to some degree. So, for example, if a court is being asked where this P should live, what does P think now about the various options is a matter of immediate importance to the court. And the practice is fairly well settled that P's litigation friend, who will commonly be the official solicitor, but not always, will file an attendance note setting out an account of their meeting or meetings with P and what P themselves said or indicated by their behaviour. We tend to see a greater emphasis on past wishes and feelings, where the decision of the court is about disposition of property, especially gifts and statutory wills. In those kind of situations, it is more common to see a relevant written statement made whilst the protected party retained capacity, for example, in the form of an old will. But often this opens up the interesting question of how to balance P's past wishes against his current wishes when they're not the same. So how much does a recent view about person X, perhaps delusional or paranoid, developed in the context of declining cognition, how much does that current view weigh against a previously long-held positive, mutually supportive relationship with P and X? Now, apart from a reported account of what P is currently saying, or a written document from when P retained capacity, how else is the court going to ascertain P's wishes and feelings? Well, just as in your jurisdiction, usually other litigants will be very keen to tell you what P's wishes and feelings were, or even are, but almost always that account aligns very neatly with what that litigant wants. Of course, it may be that this is why the litigant brings the application or raises the objection. Alternatively, it may be that the litigant's own interests infuse their account of what's going on. But increasingly, the court will be asked to hear from P directly. This is not taking formal evidence from P, and it's definitely not cross-examining P, like in your BKR case. But what happens is that P's representative will tell me, P would like to talk to you directly, can we arrange that please? And we set some ground rules with all of the other parties in the case, and usually the ground rules are that this will be just me, P, whoever is appropriate to support P, it might be a carer, and P's representative who is going to take notes. And that note will be typed up and shared with all the parties very quickly. I usually make it within 24 hours. Or if we're doing this immediately before the hearing, I will give a verbal account of what I've been told. And it takes place as a chat, essentially. I use open questions as much as possible, and I accept without challenge whatever P is telling me about what they think or feel. And that's absolutely consistent with the Act, because Section 4.4 of our Act requires that a best interest decision maker must, as far as reasonably practicable, permit and encourage the person to participate, or to improve his ability to participate as fully as possible in any act done for him or any decision affecting him. Now, of course, there are resource applications here, and it can't happen in every single case, not least because the arrangements for a judge to see P take time to make, and they take time out of the court day, particularly if P is not physically able to come to the court. And it's not uncommon then to spend a whole morning to get to spend, say, 10 minutes with P in a care home who isn't able to say very much of substance which would be likely to materially affect the decision. Nonetheless, in my experience, it's almost always a useful exercise because it gives you a much more rounded impression of the person for whom we are making decisions. And perhaps in this area, there's been one very positive effect of the pandemic. The English Court of Protection has made more technological progress in the 18 months of the pandemic than it had for the rest of its entire existence. So it has become possible, in an appropriate case, to have a remote meeting with P by Zoom or Teams to the satisfaction of P, to the assistance of the court, and much less demand on the resources. And I've had some very useful examples of meeting P in those circumstances. So from a practitioner's point of view, what is the useful information about wishes and feelings that the court wants to hear? In substance, that depends, of course, on the decision at hand. But for example, if I'm deciding where P should live and be cared for, and I'm told that P's wish is to live at home, I need to have information about what P means by home. So if P is able to tell me about the place where she lived immediately before she was taken to hospital and which is still available to her, that's one thing. But if P is telling me that home is with her mum and dad, when in fact, sadly, they died many years ago, then I'm immediately given quite different information about the practicability of P's wishes. But it's not just substance that matters, it's also how those wishes are expressed. Is P distressed and suffering from a sense of being thwarted if her wishes are not realised? Or is it only when someone explicitly asks P about the issue that he expresses any view on it at all? And how consistently are P's wishes and feelings expressed? So, in short, the more information about P's wishes and feelings, the better. And I hope the closer we will get to finding the right decision for them. And what I mean by that is what Baroness Hale described in a case called Aintree and James, paragraph 39. I'm just going to read her paragraph because it seems to sum it up to me, the approach that we are taking. The context of that particular case was a medical treatment issue. The most that can be said, therefore, is that in considering the best interests of this particular patient at this particular time, decision makers must look at his welfare in the widest sense, not just medical, but social and psychological. They must consider the nature of the medical treatment in question, what it involves and its prospects of success. They must consider what the outcome of that treatment for the patient is likely to be. And here's the key phrase: they must try and put themselves in the place of the individual patient and ask what his attitude to the treatment is or would be likely to be. And they must consult others who are looking after him or interested in his welfare, in particular for their view of what his attitude would be. I think that is the kind of approach that we are all striving to take in the context of working out P's wishes and feelings. I think that brings me to the end of any useful comments that I have for you, but thank you very much for listening.
Thanks so much, Judge Hilda. We do have quite a number of interesting questions. I thought we should discuss this one. This is question number 2, and this is what it says. How do we determine if P's current wishes and feelings are valid, especially when there is conditions like dementia that could cause paranoia, delusion? If very different from his wishes and feelings before P had cognitive dysfunction. How do we know that the current wishes and feelings are not because of his cognitive condition? So I suppose at the back of it is, what is the weight that we put between P's current wishes and P's past wishes? And for instance, if P is someone who had carefully instructed a lawyer to write out all his wishes in a formal document, the equivalent of a will, how would the court weigh it? Would the present wishes always be more important than the past wishes? How do we strike a balance there?
Are you asking me that question?
Anyone, maybe Judge Hilda.
Okay. Well, I'll offer a response, and that's to question the use of the word valid, really, because I don't look at wishes and feelings in terms of validity so much as in terms of how much they are going to lead to the ultimate outcome. There is a very valid philosophical school of thought that we aren't the same person in our 70s as we were in our 30s. So wishes when you're 30 were valid then, wishes when you're 70, whatever the background, are valid now. But how do we give weight to changing wishes over time? I would suggest depends on the context of the decision being made. And if we're looking at a decision like, where is P going to live now, then I would suggest that the immediate view, whatever the context of it, has probably a greater weight than a historical view, not least because it's the immediacy of the situation that's going to affect P. Whereas if we're talking about a statutory will, and over the last 30 years, P has made a series of wills leaving everything equally between their children, but in this state of quite advanced cognitive impairment, they suddenly get a view that one of their children is not trustworthy and they want to make a will cutting it out, then you would look probably give a greater weight to past wishes and feelings, because most people would say that the disposition of their estate after they've died, remember this is only going to be after they've died, would want that to reflect their experiences over a long lifetime. So perhaps you might view it differently in that way.
Judge To, you had a decision in the court where I think the patient had a note. He or she did a own note where she said that she wanted to be treated in private hospitals, and there was a tussle between the donee and the sister, and I think
right.
Judge, you came to a conclusion that might not be indicative of her wishes. Perhaps you could share a bit on your thinking in assessing notes or statements like this from P.
Okay. Yes, I did hear that case, and it went up on appeal actually. I can't remember the detailed facts, but yeah. I think it was the circumstances in which such documents are being written out that the judge will have to weigh how persuasive, how much weightage to give to this evidence, and of course, at the end of the day, it's also not okay. The big test is best interest, but there are other considerations such as how practical it could be as well. I mean, I think the lady spent a long time in one of our private hospitals, right? And the first bill was already more than 100K, if I didn't remember wrongly. So every time if she goes into this kind of treatment, and you do need to put her in these facilities, you will not know how much. I mean, unless she has plenty of insurance coverage, right? I mean, for most of us here who are citizens, we all know, right? If you buy a lot of insurance, then yes, straight away you go Mount E or Mount E Novena. Okay, that's the private hospitals for our foreign friends. But if you don't have insurance coverage, most of us will probably head to SGH or one of our government hospitals, because there's always the safety net of subsidies and etc. So to me, at the end of the day, it's also how feasible it is, whether you have the financial means. If you have it now, is it sufficient to cover you until the very end, etc.? Yeah. So I think it's not only the wishes of the patient, but it's also a whole host of other factors that we need to consider. Yeah.
Okay, so kind of self-interest, it doesn't equate to best interest. It is still a holistic assessment.
Yeah, in my view, yes. Because I mean, all of us would like to be treated well, pampered well, etc. But then, how does it play out? Eventually, when the bill comes, is that enough? What if you are at the age whereby you may live for another 20 years, for example? Is the money going to last? You know, when I hear my cases, I often do a big calculation of all the savings and assets, how many years it can cover, and at the hearing for the lawyers who come before me, I'm sure you will hear from me, you know, this thing is going to last for like another 5 years if you spend it this way, or it will last for another 10 years if you spend it that way, kind. Yeah.
Okay. Well, how about Alex and Christine? What would you think? Do you think you would recommend to your clients to write up their wishes and feelings at the present moment when they have mental capacity, and then kind of update it along the way, and hopefully it's of use if there should be any litigation?
Hi, hello everyone. Thank you for having me. It's Christine Smythe here. We have a very different system here in Australia, and I find it fascinating how it compares. It's very different structurally, but essentially the principles remain the same. We don't have professional guardians here in Australia. We do have professional financial administrators. So the only two options that we have in this country are the public trustee, the adult guardian office, or an individual who might be a family member. Now, in terms of expression of wishes, only recently as last year did we amend our powers of attorney legislation and guardianship legislation, and we've always had the opportunity and the facility to have a document of expression of wishes. But in that new amendment in Queensland particularly, they incorporated this idea of an expression of wishes. One of the difficulties with that in our system is that we have a very defined substituted decision-making regime. Victoria, one of our states, also amended their legislation and brought in what they call a supportive decision maker, but that doesn't really go as far as you folk would go. A supportive decision maker is simply someone who can go along and assist the person who has capacity but may be extremely vulnerable to make certain decisions. So yes, we are encouraging people to express their wishes, but the difficulty with that is once we get into the realm of the substituted decision maker having the power to make those decisions, they have to follow the best interest principles, and depending on whether it's a guardianship issue or a financial issue will depend very greatly on what decision gets made and how much of an impact those wishes have.
So shall I just chip in very briefly? So hello, thank you so much for the invitation to speak. This is just so interesting. It's one of my favourite things doing comparative law. So in terms of wishes and feelings and what lawyers here would do, definitely suggesting writing things down. But I was just really reflecting on the exchanges about priority being placed in terms of current versus past, and Judge Hilda's allusion to the philosophical debate. If you haven't seen the recent case we've had here called RePW, it's worth Googling. Jehovah's Witness refusal of treatment. Twitter has kind of collapsed with people getting very cross about it, because she had made an advanced decision to refuse treatment, which, if valid and applicable, is binding. So nobody could treat in face, except our MCA, and I should really go and see whether the Singaporean MCA does the same, has a very cunning let-out clause, which is, it isn't valid and applicable, or it isn't applicable if you have done something inconsistent with it remaining your fixed decision, and done something can include after you have lost capacity to revoke. So in this case, it all turned on whether what she was doing post-incapacity, in terms of saying she wanted blood or was willing to accept blood, overrode her advanced decision. It's an enormous punch-up between two schools of thought, and how people react to it really identifies where people sit. It's definitely worth Googling, just as a way in which to kind of see how some of those have been worked out in a medical treatment context. Obviously, as I completely agree with both judges and Christine, how things might work out in the property and affairs context might be slightly different.
Yeah, I think that one is quite interesting. I suppose it's a bit like, when the child refuses to take his medicine, that's not really the best decision. And then you need to see whether there is any consistent act subsequent to the wishes that are expressed. I suppose that will override it. So it does sound like trying to put in a document to set out wishes and feelings is not so straightforward, and of course definitely not conclusive. We all end up in court. Right. We have one more question here that's for Judge To. The question is number 4, and it is, being that we don't have the Solicitor General as peace litigation friend like in England or Wales, should we have a Board of Visitors conduct more visits or take charge of more cases to assess peace wishes and feelings? Should the Board of Visitors be more actively engaged in this sort of cases?
Okay, the Board of Visitors is appointed by the Minister. It's not appointed by me or any other judge. So, I mean, of course, it's resource intensive, to send in the team, one doctor and one psychologist or social worker. So I think we have to use it when it deserves. I mean, when the need arises, it cannot be that most majority of the cases we're going to trigger this. Then can you imagine? How much funds and resources we need to put in for this? But so far, it has happened. As in, when we need to, we will send in, and as I say, the court doesn't appoint these visitors, so I'm not sure whether they are paid or things like that. I think at most is more like voluntary basis or honorarium kind of thing. Yeah. So they are appointed by the ministry, and public guardian is the one who also helped to administer how you operationalize all this, and the court will call for such initiatives or such measures to be carried out, and so far has worked well.
Do we have something like this, similar to this, in the UK?
Yes, yeah, we do. The Office of the Public Guardian, which is actually an office of the MOJ, maintains a panel of panel of deputies as well, but also a panel of general visitors and special visitors. But it is the court that finances that panel. In theory, there is a budget, and the court is paying the OPG. This is a bit of a theoretical movement of funds, but we have never exceeded our budget, but there is that constraint on it. And special visitors are instructed really in circumstances where the court needs capacity evidence and there isn't another realistic way of getting it. But for whatever reason, it's not possible that the parties can actually get an independent expert, something like that. And general visitors are used really as the eyes and ears of the court if you want to get information about background and things in a way which doesn't require an excessive burden on a non-represented P. You can send a general visitor with a list of questions to ask, and they report on the answers.
Okay. Well, let's move on to our second issue then. This probably of great interest to lawyers. What are we doing in this arena of ascertaining mental capacity of the person, right? And we are all familiar with the case of Ray BKR. Ray BKR and the various subsequent decisions in Singapore clearly stated the test as to whether a person lacks capacity as having two components. There's the clinical aspect and there's the functional aspect. Right? The clinical aspect is more as to whether there is a disturbance of the brain or mind, something that is within the arena of the medical experts. The functional aspects tend to be how the person function, and it tends to be more reliant on the facts from people who are close to P, the relatives, the friends, the family members. So then the question is, what are lawyers doing in all this, assessing whether the person has mental capacity to do a will, to sign contracts, or even lawyers as certificate issuer in the lasting power of attorney, right? So we have a recent decision in Singapore, BUV and BUU, where the Singapore court held that based on the facts of the case, the evidence of the lawyer who was a certificate issuer of the lasting power of attorney cannot be accorded much weight, as he was not trained to assess capacity and did not know that the donor had dementia at the point in time. Right. So in that context, what is the lawyer's role in the assessment of mental capacity, and what are we in for if we get it wrong? Christine, maybe you would like to share how things are done in Australia.
Thank you. It isn't as straightforward in your jurisdiction, in our jurisdiction, as it is in your jurisdiction. We break it up significantly. We tend to rely on the common law with respect to the spectrum of tasks before the person. In terms of the role of the solicitor, it's still considered to be quite high in this country. There is the decision of Pistorino and Connell. It's a Victorian decision in which a person, an elderly person, had mental capacity to conduct her general affairs. However, she was engaged in a Supreme Court litigation over the estate of her husband, and that involved complex taxation issues. And it involved a requirement for her to comprehend those complex taxation issues in order for her to properly instruct her solicitor and her barrister as to settlement proceedings, etc. Now, I don't know about you folk, but most of us would struggle with taxation affairs generally, particularly under the Australian regime. And so the question was, could the legal representatives follow her instructions given that she was struggling to comprehend this process? They felt that she couldn't. She refused to submit to, on their request, she refused to submit to medical assessments with respect to her mental cognition. So they trotted off to the Supreme Court of Victoria against her wishes and sought an ex parte declaration as to whether or not she had the capacity to continue conducting the litigation. And in that decision, the court said that it was proper and appropriate for the legal representatives to bring that application, and that while preferable, it's not required for the court to have medical assessment as to capacity. And we take a very different view here, that is, solicitors and barristers are in fact considered to be trained in making assessments around legal capacity, and that the court could make its own determination based on those opinions. And in that particular decision, they found that she lacked capacity. So that is just one decision in terms of the role of the legal representatives in Australia generally. There are some tweaks and differences between states and territories, but that's how we approach it here. There have been some views expressed that we should be eased off from that responsibility, but it seems as though the courts here take the view that as it's a legal test, and lawyers are trained in the law and the various ranges of tests, and there are different ranges of tests according to the tasks, mostly common law, then the role of solicitor is quite integral in that if a solicitor is involved at all.
What about in the UK, Alex? Is it any different?
Yes. Yes and no. It's fascinating hearing the sort of perspectives put forward. Is this the point? Shall I share some slides now, as it were? So, yeah, good. Okay, I'll just do that to orient myself in time and space and people listening. So, this is just very briefly to outline the position in England and Wales, the statutory position in England and Wales. You can see for people, for Singaporeans, this looks very similar to your capacity test. And we basically got an identical capacity test, statutory capacity test. One of the things I find fascinating is the way in which you might apply it in a different way, slightly different way, but it's the same statutory test. What we've also got sitting alongside that are a lot of common law tests. And there's endless interesting debates as to the extent to which either the statutory test in the MCA should assimilate and take over previous common law tests, or whether the common law should in some way sort of orient itself through judicial decisions to mesh with the statutory test. So, and you can see here that our section 2 says for purposes of this act. And a lot of people thought, well, we've just passed a piece of legislation which covers mental capacity for all purposes, and it very obviously doesn't. And we just had another case, which says testamentary capacity isn't governed by the MCA. Capacity to make a contract isn't governed. Capacity to instruct your lawyer, to be honest, query, actually. But certainly capacity to make a decision, or capacity as to whether or not you are a protected party in proceedings, therefore requiring someone to give instructions on your behalf, is definitely governed by our statute. It's fascinating working out why people think it should or shouldn't apply. I think it's very revealing of where people come from and professional cultures. What's interesting also is that if you get to court, at least in the court of protection, the judges routinely will say things like this. I'll be fascinated to hear Judge Hilda's perspective on this. These are two extracts from judges of the High Court sitting in the Court of Protection talking about capacity. And that first one looks pretty similar in some ways to the BKR decision. So in other words, medical evidence very important in relation to whether or not someone's got something wrong with their mind or brain, but ultimately it's a call for the court to take on the basis of all the evidence. And SY is a case I quite often use in training, because I do a lot of training, for instance, of social workers who quite often feel that they're not allowed to think about capacity. In fact, they very much are, and the courts will say, you're entitled to think about capacity. What we want is we want the best quality evidence, as opposed to necessarily the evidence from a person of a particular discipline, is at least my experience. But of course, this is in the Court of Protection applying the MCA. And then in the context, say, of a dispute or a situation about somebody making a will, does somebody have testamentary capacity, we've got a very weird thing going on, an actively weird thing going on, which is if you were to come before the Court of Protection to ask for a will to be made, a statutory will to be made by the Court of Protection, you'd have to satisfy the court that the Mental Capacity Act is satisfied with the Court of Protection is governed. If you're in a situation where you're not, there's no suggestion that a person currently lacks capacity and you're trying to make a statutory will, you're trying to head off an argument after the person dies, you wouldn't be going near the Court of Protection, you'd be in the common law zone, and then you're in the zone where the lawyer's going, am I supposed to be relying on my own assessment here? Am I comfortable, confident that I should be doing it? Or should I be following what we regularly call the golden rule, which is go and find a doctor to tell you? But it's a rule of practice, and the courts keep saying it's not saying it's going to mean there's never going to be a dispute. You're trying to minimize dispute. So a lot of it is about making sure the lawyer is not there. What they did is then not called into question afterwards. And so there's some quite weird incentives going backwards and forwards. And I suspect one crude way of putting it is, if we're in the real-time zone, then the evidence of the lawyer, or the role of the lawyer, is going to be more likely to be more important because the lawyer is the person who's saying to the judge, whether it's in the court of protection or in other litigation, I think my client's got the capacity to give me instructions to do things. If you don't agree, do something. If we're thinking protecting against future challenges, the lawyers, of course, are going to be doing what can I do to make sure I myself am protected, and also make sure that my client is protected. Make sure that there isn't, post-death, some massive challenge to the probate, say. That's just our guidance. I remember in some of the planning discussions for this conference, we were thinking about, whether or not it's a good idea to have guidance. This is the Law Society of England and Wales guidance. Crystal clear, it's your job to think, does this person have capacity to instruct you? And then, by the way, there are loads of tests you might have to think about. I do think it's super interesting, the idea, are lawyers trained per se to think about capacity? I did see Judge Hilda's eyebrows reach upwards when Christine was saying, our lawyers are considered to be trained in capacity. I mean, it's a genuinely interesting question, because you've set up a test, at least our statutory test, and indeed our common law test. It's not a medical test. It's a socio-legal construct based in part on medics telling people what they think people can and can't do, but it's not ultimately a medical test, so why shouldn't lawyers be able to apply it? On the other hand, if you get a lawyer who doesn't routinely see somebody who might have impaired decision-making capacity, is it really a good idea for them to go, yes, I'm sure this person can make this decision? Yes, no, probably answers on the postcard, please. And then can I just lastly put the cat amongst the pigeons, and I know this sort of was floating around in a couple of the things earlier, but just to bring out there, we do have, I hope we know, a fundamental challenge to the idea of whether what we're doing is just simply off beam altogether. The Convention on the Rights of Persons with Disabilities making clear, it is said to make clear, there's a large debate about whether what the Committee on the Rights of Persons with Disability says goes beyond what states have signed up to, states who are signatories to it, saying mental capacity is simply an invalid basis upon which to draw the dividing line between people who can make legally definitive decisions and those who can't. It pretends to be objective when it can't be. It's pretending to see something in the inner workings of someone's mind when you can't. It's pretending to be some naturally occurring phenomenon when it isn't. I mean, at one level, it is a straw man challenge being set up. I don't think anyone here, I'm dreaming to speak for the judges, but I cannot imagine anyone would seriously say one is seeking after objective truth with objective measurements about mental capacity. You are striving to identify analog, fuzzy reality, doing the best you can to identify a binary answer, yes, no. And that's common to loads of other things. There are loads of other things where we have to do that. So it's not really so much objectivity of outcome, it's objectivity of process. But the challenge here, and different people in England and Wales take it in different ways, but it's a really good challenge to what it is you're then asking people to do in terms of the lawyer's role, in terms of the medics involved, in terms of what the courts are doing. And that's just a blatant plug for some academic work which has been done here, partly to try and think about how one thinks about capacity in more difficult cases. So that's a sort of very quick whip round from England, or at least my perspective from the lawyers in England and Wales.
Yeah, thanks so much for highlighting the wordings of the Section 4 for our Mental Capacity Act. The preamble, for the purposes of this Act, a person lacks capacity in relation to a matter, and then it goes on to set up the test. I don't think in Singapore we have had any decision interpreting that preamble yet, that the test is only for the purposes of this Act. But we did have a couple of decisions where the judges, in deciding what is the test for testamentary capacity or the test for mental capacity to do a will, at least two of the cases, the judges applied both tests. They did both the tests under Section 4 of the MCA as well as the Banks and Goodfellow as well. I suppose it would be nice to have some clarity and some consistency as to what is the test that apply. That there is also a recent case, I think, by Edith Abdullah, where he said that in order to have testamentary capacity, you must have mental capacity. So let's do both. Would that be consistent with the approach in England, or it has been taken quite separately?
There is just an enormous fight going on. The most recent fight is in a case called Re Clitheroe, where there was a very sustained argument advanced that the Mental Capacity Act governed the law relating to testamentary capacity, which was an interesting proposition because it's immediately obviously wrong, because the MCA says for purposes of this act. And unless a case is coming before Senior Judge Hilda for her to make a will on behalf of somebody, it's not obvious that the Mental Capacity Act is governing that at all. What the real thrust of the case was probably more the common law should be moulded to reflect the statutory tests. And they just aren't the same. Banks and Goodfellow, it's quite difficult, I personally think, but I will shut up in a second because I'd be super interested to hear Judge Hilda's view on this if she feels able to give it. I think that the Banks and Goodfellow test has just got different things in it to our Mental Capacity Act test, which is your Mental Capacity Act test. It comes from, and it's not just, it's relating to a 19th century conception of the world and 19th century language. I mean, the language used you wouldn't use now. But I do think, and our Law Commission, who were thinking about a project to make our Mental Capacity Act govern wills, our Law Commission doesn't think the two are the same. So it's not just me making it up. Our Law Commission thinks that there are potential differences.
Entirely off record and non-binding, of course. There I asked Judge Toh and Judge Hilda for their views on this. Should the test in the Mental Capacity Act applies also in relation to the determination of testamentary capacity?
I'm going to be pretty circumspect about what I say in this context, in case I'm asked to make a decision on it. When things come in front of me, as Alex says, it's without doubt the Mental Capacity Act test which I am applying.
Okay. Judge Toh, any thoughts?
I did some reading up before I came for this conference. I think testamentary capacity refers to the mental capacity to make a will. And then we of course have the Old English case that Singapore also follows, but restated in more modern language, right? So it's stated in a positive way, which is the mental capacity to make a will. So in order to confirm that you did have this capacity, you must go through these 4 points, right? Like what we all know the case. Whereas for the MCA, it is the other way around, right? It's talking about mental incapacity. I stress mental incapacity. So it is flipping it the other way around, which is when does a patient fall under the category of not having capacity? And then we have those provisions, right, that talks about impairment of the brain and whether this impairment causes him to be unable to make a decision. And what does unable to make a decision mean? So all these are on what our legislation covers. So I would say that it's not identical, but there are similar, it's kind of related, and there are some overlap. I think for a person who fulfills the test in the MCA, as in he doesn't have capacity, it's probably also not very likely that this person has mental capacity to make a will. So that's how I see it.
Right, thank you.
Yeah.
We have a question in the chat box now. The question is, dementia is a deteriorating condition. When the client first sees you, he may have the ability to instruct lawyers. He may still have it when signing his affidavit, and may not if he goes into cross-examination, finally when the matter goes to trial. So in such a case, should a lawyer look at what condition the client could be at the end of the case when deciding whether you can take instructions from the client versus to who he presents to you at the beginning when he instructs you? Any thoughts on that, Christine? At which point in time do you feel safe to take on a client? Do you try to forecast the mental capacity all the way to the end of the case when the matter comes up for trial?
The answer is no, and I think if we just look at it from a pragmatic point of view, we approach mental capacity in the context of deteriorating capacity. What's the difference between a client that might come to you who might be aged, or a very young client that might come to you, give you those instructions, sign off a statement, and then step outside and get hit by a bus? They're going and suffer some kind of cognitive impairment. If we all only took on cases where we could be assured that someone's capacity was going to last the length of the matter, I don't think we'd have a lot of business. And that aside, because we're not in it for the money, it's an issue of providing the services to the client as and when they come along. So in Australia, when you get to that point where you can't be cross-examined, well, that's obviously going to be a problem in terms of cross-examination. But if a client loses capacity during proceedings, and my previous firm and I have had that situation in family law matters. You take some instructions from someone, and in this country, our family law system is a complete debacle, and things can go on for years and years and years. What we then do is we look to a litigation guardian or a substitute decision maker, such as a power of attorney. So that's how I view it. Can I just pick up on a couple of things that have been said by Alex and Jachilda around the statutory will aspects here in Australia? I have provided slides, but it's too lengthy to display them here for the purposes of this panel discussion. What we have here in Australia in terms of the statutory will, it's really interesting, the discussion around the Banks and Goodfellow test, is that we have statutory will legislation, but the statutory will legislation doesn't specify a test for capacity. We rely on the Banks and Goodfellow test in order to bring an application for a statutory will. And we had an application like that here in Queensland, and I wrote up about it, and the name of which escapes me right at this moment. But in that particular decision, what was observed about the incapacitated person was that they were non-verbal. They were unable to communicate their thoughts and their views. They effectively had something like locked-in syndrome. And so the judge in that decision was relying on third-party evidence about what their views might have been. And he observed that the Banks and Goodfellow test does not have a component of the ability to communicate. We have legislation, our powers of attorney legislation, and when you go to enter into a power of attorney, one of the parts of that statutory test is the ability to communicate in some way. So for the purposes of power of attorney, the test involves the ability to communicate, but for the purposes of Banks and Goodfellow, we don't have a requirement that they have the ability to communicate. And the judge in that decision raised the very same question I think yourself mentioned, how old that decision is, and the advances in technology, and how we may look to legislate a better capacity test for wills. So just thought I'd bring that attention to the attention of delegates to show how differently we're approaching things here.
Yeah, thanks so much. Anyone wants to share any thought on this question? I think in Singapore, typically, if a client comes to you and if you're not sure or have any doubts that his capacity is going to last the entire duration of, say, the trial, then we should seriously consider applying to court for the appointment of a litigation rep. That will be the solicitor's protection. It's very difficult to take on a client who you don't have full confidence who will stay with you for the entire course, that there is some risk and dangers in that.
Can I just interject that raises the interesting possibility that you might be asking for a litigation friend at a point where the client actually still has capacity. That would be interesting on our side of the world, kind of thing. But what I would suggest is that this is a live issue, and it has to be kept under review constantly as the litigation progresses. And I have certainly had cases start off where one litigant is giving the instructions directly to their solicitor, but halfway through the first day of the hearing, the representative raises, I've got concerns here about this person's the capacity to instruct me, and the whole thing has to wait whilst further decision is made about whether a litigation friend is needed or not. That's not P, that's a different litigant. And in respect of the protected person who's the subject of these proceedings, that's one of the two situations in which the lawyer's assessment weighs comes to the attention of the court most consciously. The other one is the certificate provider for a lasting power of attorney. That was an innovation for lasting powers of attorney over and above what was the pre-existing position in respect of enduring powers of attorney, which didn't have a certificate provider. And the purpose of the exercise was really to try and pull the rug under the feet of those arguments later on that this person never had capacity to execute the LPA. It's my experience that the usefulness of the certificate provider has unfortunately diminished as a result of the change of forms of LPAs, which is not statutory at all, but you actually know much less about the certificate provider under the current set of forms than you do under the original set of forms used by the Office of the Public Guardian. Just throw those in for thought.
Yeah, that's quite interesting, and it does bring to the front the issue as to lawyers who act for P. You know, the client comes to you and says that the relatives or the friends are challenging his capacity. What are the safeguards that the lawyer can take when they act for such a person, right? In the event that the court were to rule against your client's position, rule against P's decision, and they were to find that P doesn't have mental capacity and after all, something like in Ray BKR, what are the things that the lawyers could have done to put themselves in a better position to protect themselves against any fallouts?
I think one thing, I think there's a sort of point I'd really want to draw out here, which is there's going to be a difference, and there may well be a difference in some cases between the person's ability to make the underlying decision and the person's ability to give instructors to lawyers to do something about it. Different judges here have expressed different views about that. There's quite an outspoken judge, Mr. Justice Mostyn, who just expressed a view that it would be as rare as a white leopard to have somebody who didn't have capacity to make an underlying decision, but had capacity to instruct a lawyer. I think there's a very interesting debate there, especially in any case which might be governed by our Mental Capacity Act, and we just had the discussion about what cases are and what cases aren't. Because, of course, our Mental Capacity Act, as does yours, includes a requirement that all practicable steps are taken to support the person to make their own decision before you conclude the person doesn't have capacity. So if you are a lawyer acting in a case which might be before the Court of Protection, are you part of the practicable steps to support the person to make their own decision? Not necessarily the underlying decision, but you could be helping. One of the things you might be doing is helping the person understand the chain, all that kind of stuff. But are you also somebody who's playing an important part in playing the person going, I know I may not be able to make the underlying decision, but I should be able to make an argument about how it should be determined. And I think I know that they're just different feelings about that. And obviously there are going to be some situations where the two are obviously aligned, but I think it's always important. I certainly take very strongly the fact that it's very important that our statutory capacity where it applies is decision specific. So I mean, I think in terms of protecting the person whose substantive decision-making challenge might be in question, that's where things like the equivalent of our golden rule come in. You're trying to bolster the person. But of course, I do think it's always important to think, are we talking real-time decision-making, or are we talking bolstering what might happen after the event of the person's death, and you can't go back and do something about it? And I do think there are just different considerations there.
Right. And Christine, you mentioned previously in our discussion that there are various guidelines from various societies, organizations in Australia raising red flags or providing checklists as to how a lawyer can assess the mental capacity of the client. Did you find these guidelines or this checklist useful at all?
I think they're proportionally useful insofar as the level of experience you have. They're also useful in terms of refreshing. your position. If someone could bring that slide up of the number of guidelines that I was able to find just quite quickly, it's on the slide, one of the slides. One of the difficulties that you have is the Queensland guidelines under the guardianship legislation is quite lengthy. And so you've got this balancing act that you've got to engage in terms of if you sit down and you follow these guidelines, how long do you engage in this process in terms of the task before you? And I think that that's really quite important. I think it's the third slide along, if you can bring that up. And the issue there is, what task are we engaging with? So this slide here is quite helpful to give you an indication of the range of legislation. So we have 8 states and territories in Australia. We have legislation that deals with powers of attorney legislation. Now that's to deal with financial matters and to deal with personal matters, which don't include medical matters, which is what everyone was speaking about before. We have a separate requirement for the medical matters. In terms of the guardianship, we've got the separate guardianship legislation, and that's to deal with making decisions about where you live, what food you have, who you visit, and so on. And then we have each jurisdiction has a administrative tribunal, which is a self-help jurisdiction. It doesn't, the rules of evidence don't apply. You have to seek leave for lawyers to be able to assist the tribunal. Leave is not a given, and so that can be problematic. We do have the ability to go to the Supreme Court, but if you go to the Supreme Court when you could have been in your QCAT or one of the administrative tribunals, you get a slap on the wrist to be sent back. And so you've got this financial issue going on there in terms of being able to assist clients, because you can give clients legal advice, but right up to the date of the hearing, there's no guarantee that you'll actually be able to represent the client's interests in the courtroom. Now, the next slide talks about the guidelines, and these are the different guidelines that we have, and they're across our different states and territories, and it depends on what jurisdiction you're in as to which guideline you're going to resource and follow. And as you can see that we've got the Queensland State Government's issued its own capacity assessment guidelines, whereas the Office of the Public Guardian has also separate guidelines. What I haven't put up there is we're very insurance driven here in Australia, and particularly in Queensland, that is, because we have what's called a captive insurer, which is actually incorporated in Singapore itself, and that captive insurer pretty much insures most of the lawyers in Queensland except for the large law firms, and they themselves issue guidelines, and it's a very insurance driven process around what degree you should engage in assessing your client's capacity for the task. Now, to give you an indication of that, there was a family court decision, and this comes back to this issue around the client being able to give evidence. There was a family court matter involving a client, and he was on the steps of the courtroom. The matter was about to be heard, and he was a resolution proposal was put to him literally outside the courtroom by his barrister and his solicitor, and he signed off on it. And then he later sued them in negligence on the basis that he suffered from post-traumatic stress disorder, which impacted his decision-making capacity. And the case goes for over 460 pages. The name of it, again, escapes me, but I can provide it to people if they're interested. And the barrister was able to escape the liability because of advocate's immunity, but the solicitor was not. And in that decision, they went to a great deal of length to try and get ethics rulings around what instructions they could take from this fellow, because he didn't have lost capacity in the sense of deteriorating capacity. He had a mental illness, post-traumatic stress disorder arising from serving in, I think it was in Afghanistan. And so his capacity waxed and waned according to whatever day it was, and it just so happened to be on that day. he said his capacity was diminished. So we do take a very proactive approach in ensuring that we're not going to be the last person holding the ball in terms of liability issues and decision making. And coming back to the question around do you take on a client who may or may not be able to last the distance, one of the things that we do is we ask around, do they have an attorney appointed who can step in? That's always very helpful. And if we're worried about capacity, we also ask them to go off and get an assessment by a specialist geriatrician. We don't really like just GP assessments. And our insurer actually provides us a very lengthy letter setting out those tests. So we've got more than enough resources available to us. It's a question of sitting down and familiarising yourself with those resources. And we have had legal services decisions, particularly in Queensland, around the perceived arrogance of some senior lawyers not to take into account some elements associated with assessing someone's capacity. And one particular decision involved a very senior lawyer who decided that he knew what was best and chose not to speak to the aged care workers in the aged care facility where he was taking the instructions for the will and the power of attorney, and he really didn't go through a process. So to answer your question, yes, they are helpful. Can they be onerous? Most definitely. How do we use them? Judiciously. And that is, and we have to weigh that against what the client is prepared to pay. Because at the end of the day, if a client isn't prepared to pay to go through this process to protect them, particularly in will-making exercises, that's something that we think about very carefully. And in fact, in the will-making exercise, and only today, I saw a 90-year-old lady, and she was as on the ball as you possibly could have, but still, I was insisting that the medical certificate that she provided me wouldn't cut the mustard if there were a litigation occurred, and in this situation, a litigation is likely to occur. So off to the doctor with a 3-page letter and our insurer's certificate requirements. So yeah, so they are very onerous. There's lots of them. Pick whichever one you want. Best to pick the one in your jurisdiction. But if you notice down the bottom there, the federal jurisdiction, we are a constitutional federation, so we have each state has its own capacity to make its own laws, but we also have what we call the Law Council of Australia, which is this conglomerate of all the law societies of Australia, who also put out guidelines. And so I can see how practitioners can be quite overwhelmed and confused by that process.
Yeah, you make me feel almost glad that we don't have any guidelines in Singapore.
Borrow ours, borrow away.
Okay, thanks so much everyone for joining me today. It's really been enjoyable. But just before I let you go, if you can have one wish in the area of mental capacity, can I ask what it will be?
I'll have a go in our jurisdiction. More certainty, more structure. We tend to have a lot going on, and it's a lot of balls in the air, and a lot of opportunity for us to be stuck with the hot potatoes. So for us, more definition and more structure.
How about you, Alex?
Interesting. I'm going to say, just to be sort of provocative, the direct opposite, in the sense that I would like there to be more support for just uncertainty. So more support for people recognising there are different views, and you will be protected so long as your view that you have taken is reasonable, which I don't think really differs from Christine, but it's just a different way of framing it, because I do think it's important. All of this is trying to do the right thing in terms of thinking about someone's decision-making capacity or reaching a conclusion about what we would say is their best interests. It's not perfection, and it's how you support people to make just uncertain decisions, not just uncertain, but as in justice.
Right. Judge Hilda, any thoughts?
Yes, I would like to have a megaphone, please. The Mental Capacity Act is a good act. The principles underlying it are sound, but the level of awareness, even among public bodies who are called upon to apply the principles and work within the act, is still too low. So I would take my megaphone to medical training institutions, to social work training institutions, to charities supporting families. We all need to know and talk about capacity more.
I love that. Judge To?
Okay, I think my last words on this topic for today would be his wishes matter. Okay, so try to find out what they are and consider them if they are suitable, or do a LPA while you still can.
Thank you. And my wish is that I do not lose mental capacity anytime soon. I hope everyone remembers this day and have a good day going forward. Take care, everyone.
Thank you very much.
Thank you.
Thank you.
Thank
Thank you,
you.
everyone. Bye-bye.
All right.
Thank you, everyone. Thank you to the panel. Thank you to the moderator. It was a wonderful exercise in thought and thinking. Can you imagine? We all drew from the same pot of the common law, and yet we have developed in different ways, and yet we're all struggling to do the right thing, and yet in so many different ways. So thank you all speakers for sharing. Ladies and gentlemen, we will now take a short break, and the next session will start at 3:20. Let me repeat that, we're pushing back a little, 3:20 p.m. Okay? So we'll see you all back here at 3:20 p.m.